Oh, hi there, everybody. My name is Christie Asselin. I'm a local attorney here in La Crescenta. I am an estate planning attorney, and I met Natalie, who runs this group, a few months ago at a presentation I did for Moms Club, which is a group we're both in. And she asked if I would be open to presenting for you all, and I said, yes, of course, I'd love to. So here I am. Things haven't gone quite as I expected technically, but we're making do with what we have. I'm going to record this webinar and then make myself available to answer questions during the time that we've scheduled for the webinar. So I'm going to go ahead and share my screen, and we'll get started. Oh, okay, great. Okay, so as I mentioned, I'm a local attorney here in La Crescenta, and also have an office in Pasadena. You can find me at lawyercma.com, and you can call me at 818-248-2183, and you can also see my my email address down here. So, first question, why do I need an estate plan? I consider estate plans to be really good problem solvers. They anticipate issues that can happen in the event of someone's incapacity or death. You know, it's like when you're pregnant and everyone and their brother comes up to you and tells you their horrible labor stories. Same thing can be said for estate planning. Everyone tells me these, these tales from the front about problems that they've had with estate planning. Well, estate planning not done correctly, I should say. Once, for instance, my doctor was the trustee for her sister's estate, and her sister had passed away, and previous to that, of course, she had put together an estate plan through like a LegalZoom, or it's called We the People. And she had made some mistakes, and she hadn't done an efficient job of creating this estate plan. And so my doctor basically had to go through about 2 or 3 years of court, and the estate spent something close to like $60,000, a lot of money, to get the property to the right people, because her sister just hadn't done, had saved some money by doing it DIY style, and in the end, it cost a lot of money to fix. What you should know also is that the law already has an estate plan for you. There are just rules out there about how what happens to us in the event that we pass away, or if we're incapable of making decisions for ourselves. So by drafting an estate plan, you really are calling the shots in terms of how you want your property to be distributed, and also who you'd like to nominate as guardians for your minor children. So probate court, you're going to hear me use this phrase a lot. It is an arm of the civil justice system here in the state of California, and probate is the way that the court comes in to administer someone's estate, and also to determine the validity of a will if it comes into question. For most of us, the goal of estate planning is to avoid that process for our loved ones, and it's because the probate court process is very lengthy. It can take several years, and it's also very, very expensive. I assisted on a probate case recently, and it took 6 months just to get a court date. That gives you any kind of perspective on just how lengthy the process is. So for most of us, we just want our loved ones to be able to avoid probate. So what is an estate plan? Well, I'd say that there are 3 main aspects. There's first the documents, and the documents consist of a will and or a trust, and powers of attorney, and an advanced healthcare directive. The third part that you don't hear about on those LegalZoom websites is the importance of funding the trust, and we'll go over that as well. Also beneficiary designations, which we will also go over. So let's talk about the documents and what they are. So will is what I consider the process by which you gather all of your belongings, and you designate where you'd like them to go in the event that you pass away. It's also where you designate or you nominate guardians for your minor children. A trust is where you say, you give specific instructions as to what you'd like to happen to your property. I'll go over this in a minute, but if you have over $150,000 in assets, gross assets, then what you would do is you would gather all of your assets, indicate it in your will, and then pour over your assets into the trust. So those documents act together. There's also a power of attorney, for financial and property. And that means that you, in the event that you're unable to make decisions for yourself, in the event that you're really sick and in the hospital, or if someone's in a coma, they can pre-designate someone to handle their finances for them. The power of attorney for medical and advanced healthcare directive, those are beneficial when someone is, like I said, in the last situation, very sick, or someone is in a coma. You can designate someone to make decisions for you, some medical decisions. This is a very personal area where people have very strong opinions about things like artificial respiration, feeding tubes, all the end-of-life care type decisions. And this is a way that you can, one, think about what your preferences are, and then designate a loved one to make those decisions for you with knowledge of what your preferences are. So this document will both designate a power of attorney agent and also set forth your wishes. And this is a particularly good form that I like. It's prepareforyourcare.org. It is put together by the UC Regents, and I think it's a really good form and has a lot of really useful information. So people sometimes ask, are you sure that I need an estate plan? I have a very simple wish, right? And the answer is most likely yes, if you fall into a few categories. One, if you're a parent, you definitely should have an estate plan. At a minimum, you want to have a will wherein you nominate guardians to take care of your children in the event that you're unable to. If you have a home, you're going to need a will and a trust. I'll explain why in a second. If you have a bank account, you're going to need a power of attorney for financial. That's all of us. If you have a physical body, you're going to need a power of attorney for medical decisions. Again, that's all of us. So yes, you absolutely need some aspect, if not all of them, all of these documents. Excuse me. There are some common misconceptions. First, I think people sometimes think that this is just for the 1%. And that's just not true here in California. If you are a homeowner here, you will absolutely trigger the threshold for triggering a probate process, which again is a very long and expensive process. If you have a home, then you're going to easily go over that threshold. The threshold is $150,000 of gross estate, which actually is not very much money if you have a home here. So if you own a home here in the state of California, especially Southern California, especially Los Angeles, where everything is so expensive, you're probably going to go over that $150,000 threshold. If you have a child, you really want to nominate guardians. You can do that through a will. So this is the place where people, I would say, along with making decisions as to healthcare, this is a place where people really struggle in terms of deciding who is going to be the best guardian, who shares their values, and who is going to be the best to raise their kids in the event that they can't. Can you have a will and not a trust? Yes, absolutely. If your gross assets are less than $150,000, you can just have a will, and that's perfectly fine. Can you have a trust and not a will? I definitely advise against that. And that is because within the will, it will have a provision called a pour-over provision, which is basically an insurance provision in case you forget to put something into your trust. It says, oops, if I forgot anything, I mean for it to go into the trust and for the trustee to handle that for me. So you need to have both of those, a will and a trust. If your gross assets are over $150,000, you need a trust. Sometimes people think, I'm young and healthy, I don't need it, this is something that can wait, which, I mean, we all hope that we live long, healthy, amazing lives. But when you're young and healthy is the time to start planning for this. I was speaking with a friend of mine who went to medical school with a couple that met in medical school, got married, had a family, and at her reunion she learned that they had passed away without an estate plan. That's a headache, right? I mean, it's terrible, and I'm sure the family grieved, and that's a terrible situation. But adding on the complication of having no estate plan is even more difficult for our loved ones. You know, sometimes that's the one thing that they can lean on, is that they know that they at least don't have to handle a big probate process in the midst of grieving. So now is a good time to start planning. So the most important elements are the creation of the documents, which are a will and or a trust, your power of attorney for financial decisions, power of attorney for medical decisions, and advanced healthcare directive, and then funding of your trust. This is a very frequent problem where people think just by creating a trust that that's all they need to do, and that's just not true. Title to the asset must be changed. You must take your hat off as the individual and put it on as trustee. So title to your home has to be changed from Scott Fitzgerald as the individual to Scott Fitzgerald, the trustee of the F. Scott Fitzgerald Trust. It's really important. Account beneficiary designations. I'm going to give you a little bit of homework, which is when you are in front of your laptop or computer later on today, look to see if you have beneficiary designations on your bank accounts. Frequently, people don't, or they don't have a payable or POD, payable on death designation. What you want to do is have those lined up. Really, you want all of these elements to kind of be choreographed together so they all work together to achieve the goals you have for your estate plan. Okay, so we're going to talk about the statutory will. Statutory will is just a form will that I happen to like. It's not going to be enough, most likely, if you own a home or if you have over $150,000 in assets. However, it is like a decent start. So the will has, the California legislature has set forth some very specific instructions for executing a will. You need to find people who know you, who are not going to be agents of yours or trustees or executors. You want to find people who are not going to be beneficiaries of your estate. So people often choose neighbors or good friends that just aren't going to be beneficiaries. They need to be there to witness you sign the will, and they have to attest to your capability to sign the will. So you want to exchange numbers with friends and maybe make a date. Maybe they also want to create a will, and you can sort of work with each other. And to find I'll link to this below, but to find the statutory will, here is a blog post on my blog about just free estate planning resources. So if you have a current estate plan, tune this out. I don't want you to touch it. And that's because, like I said, all these documents are choreographed to work together. So to add in a red herring will really probably isn't going to help you reach your goals. Choosing a guardian. So a guardian is the person who, if both parents pass, both biological parents pass, the nominated guardian will be responsible for the child. I shouldn't say biological parents. I should say legal parents. The nominated guardian will be responsible upon court approval. So people sometimes get very concerned. If they choose their guardians now, but what if they change their mind in 5 years? That's perfectly fine. Estate plans are really meant to change and evolve over your lifetime, and you can change them as many times as you want to. In fact, it's quite common to change guardians. Estate plans are generally updated or reviewed at least every 5 or 10 years. So when you pick your guardians or your trustee or your executors or your agents for your powers of attorney, you want to think about the next 5 to 10 years. And don't be thinking about 15 years down the line. You really want to be thinking about the next immediate future, because your estate plan really should be reviewed anyway, and you can change them. Layer your nominations. This is really important, and that's because if you nominate someone and they're unable to be your, let's say, guardian, then you want to have a backup as well. Because, although you are thinking in the mostly immediate future, things do happen. So you want to have insurance. So I call it layering your nominations. It's important for you and the legal or biological parent to be on the same page about who you would like the guardians to be. So if you have an ex-spouse, you really want to communicate to some extent about who you'd prefer the guardians to be. It just avoids confusion. If you are in a same-sex relationship, the best plan is to ensure you're both legal parents via adoption or pre-birth order. If you are unhappy with the idea that your child's biological parent would become the guardian, you want to kind of keep a file as to why your ex should not get custody. You want to draft a letter setting forth your wishes in this regard and include all the evidence you need to support your argument. So please report, court records, whatever you feel that is necessary to include it in that file. And if you don't nominate a guardian, a judge will appoint someone. Usually a potential guardian is going to volunteer. So you'll see in the form, there's a couple of different types. There's the guardian of the person, which is kind of like the day-to-day management of a child's life. So food and shelter and education, medical care, general welfare. And then there's what I call the CFO role, which is the person who handles their property, like their financial aspects. They're almost always the same. And you should also note that, so people typically choose them to be both guardian of the person and guardian of the property, and you should see some language on the form about that. And then you should also know that this is important, that the court is going to approve guardians. This is a really good thing because it just gets the judge involved to make sure that the nominated guardian is the most appropriate guardian for the child. Okay, so we're going to answer questions here in a second. And I'm available for a 20-minute complimentary consultation. I love to meet people. I love to talk about estate planning. So I'd be really happy to meet you. Again, I'm Christy Asselin. You can email me at cma@lawyercma.com. I'm in both La Crescenta and Pasadena. And this is my phone number, 818-248-2183. Thanks.